Okay, Assalamualaikum and good morning, everyone. Okay, so for today, I'm going to explain a new topic. A new topic which is partnership law in Malaysia. Okay, before we go further, okay, let's look at the types of business, which is exist in Malaysia. Yeah, basically in Malaysia we have four types of business, namely sole proprietor, corporation, cooperative society, and partnership. Okay, what is sole proprietor? The sole proprietor is a business run by one person only, and usually this person will use his own capital, and it has unlimited liability to its business liability if there is any legal action taken against the owner of the business. So the liability is unlimited, means that it is only the owner, if the asset of the business has been which is not enough to cover or to pay for the debt, then the personal asset of the owner will be used to pay for the debt, and it is a legacy business activity. Okay, the second one is corporation. Corporation is a company, refer to company. So for corporation, it is a company incorporated under the Companies Act 2016 or any other act which is relevant. So for a business which is registered under the Companies Act, it will be considered as a company. And once a company is registered, it has separate legal entity from its members. So the company can be considered as an artificial legal person. An artificial legal person where it has separate legal entity. So with its own legal entity, it has the right to it has the right to enter into a contract using its own name. It has the right to take legal action using its own name against a third party. It has the right to sell, to sell or to buy a property using its own name. So we can say that it is one artificial legal person which has the legal right same as a normal person, same as a normal person. Okay, the next one is cooperative society. Okay, cooperative society is a society established on the basis of an agreement made between the members, and it is governed by common law and equity. And it is not registered under a company, so it will not be considered as a company. And also the establishment of this cooperative society is not for the purpose of profit, usually for maybe for another purpose, for political purposes or for welfare purposes or any other purposes which is relevant. An example is political association, And the relationship between the members in the cooperative society will be governed by the law of contract. Okay, the last one is a partnership. Okay, partnership basically for partnership, as regards to partnership, the relevant law is contained in the Partnership Act 1961. And this is the main legislation of partnership law in Malaysia. And in fact, the act, this Partnership Act is based on and therefore similar to the English Partnership Act 1890, where it has almost identical in content, though the section numbers different, will be differed. And a number of principles of law arising from the English Act is applicable in this statute. And besides Partnership Act 1961, okay, the rules of common law and equity also will be applicable in the law of partnership. This is according to section 47 clause 1 of the Partnership Act, provides that the rules of equity of common law applicable in partnership shall continue in force, except so far as they are inconsistent with the express provision of this act. So from this provision, it's clearly stated that besides the Partnership Act, in order to resolve any dispute, the court can refer to the common law principle and also the equity, as far as this principle does not contradict with the express provision in the Partnership Act 1961. Okay, now let's move to the definition. What is a partnership? Okay, partnership is defined. Okay, a partnership is defined in section 3 clause 1 of Partnership Act, of the Partnership Act 1961, where the partnership is defined as the relation which subsists between persons carrying on a business in common with a view of profit. Okay, so based on this definition, there are three essential ingredients to be satisfied in order to determine whether the relation between the persons in disputes, the relation between the particular person can be considered as a partnership or not. Okay, the first one, is a relation between parties. In order to create a partnership, there must be a relation between parties. So the word relation, the key word here is relation. So partnership is a relationship. So it is not an organization. It is as a partnership, it is not an organization. It is own rights with a separate legal personality. So as a partnership, it has no legal entity, where the entity of the partners and the firm is considered as one entity, not separate legal entity, as different with the company. All right, so usually the article of partnership will govern the relation between the parties, but not all the firm, the partnership are having their own article of partnership. Article of partnership is referred to the partnership agreement. So it is not mandatory for a partnership to have its own article of partnership or agreement, partnership agreement. It is optional. It is not mandatory. Even though the partnership does not have has its own article of partnership, but the partnership is valid. Yeah, the partnership is valid if it is registered. All right, and the minimum number of partners is 2. For the maximum partners under Companies Act 2016, provides that for ordinary partnership, maximum partners is 20, but for professional partnership, the number of partners is unlimited. Yeah? So the difference between ordinary partnership and professional partnership. For ordinary partnership, it is involve the ordinary business. For example, burger stall, partnership business involving 2 parties, to run a burger stall. What else? Okay, for professional partnership, for example, it's a legal firm, legal firm, a clinic, okay, which involving the professional, to run a business. Okay, the second one is the agreement is for business purposes. All right. For business, what does it mean by business? Okay, for the definition of business, we can refer to Section 2 of the Partnership Act 1961, where business as includes every trade, occupation, or profession. And this definition is not limited, and it also depends on the definition given by the court, according to the facts of each cases. So it is by case basis, where the court will define the definition of business. And furthermore, okay, another definition was given by Brett Judge in the case of Smith versus Anderson, where he defines the word business. Is the word to run a business means to do something over and over again. So a group of people is formed to do just one business is not fall within the ambit of this definition. So the important thing here is to run a business, whether the act, or the sale, maybe we can say the transaction made by the parties, whether it constitute a business, if it is something which is done over and over again, then it will fall within the ambit of Section 2. However, or the definition given by the judge in this case. However, if it is only done for one time, one in a lifetime only, for example, then it will not consider as a business. Okay, for example, husband and wife wants to sell their house and they do all the work for that purpose. So it does not mean that both spouses do business, even though the sale of the house is profitable. So from this example, we can say that okay, both husband and wife, yes, they have satisfied the first element of partnership. There must be at least two person. There is a relationship between 2 parties, and they sell their house for profit. Yes, they sell the house for the purpose to get a profit. However, the question or the issue here, did they do the business? Does it mean that both of them are doing business? The answer is No, yeah, because they only done this transaction only once. But it will constitute a partnership if this both husband and wife um, they have done, yeah, the transaction over and over again. Then it will constitute a partnership. Okay, the third one is the business is for the purpose of gaining profit. Okay, what does it mean by profit? Okay, the definition of profit was given by the judge, Fletcher Moniton, in the case of Re Spanish Prospecting Company Limited, where in this case, profit means making a difference in the position of business between two specific dates within 1 year. So the basic sense is that the amount earned by that business, yeah, during the year can be ascertained by making a difference to the asset of that business on two specific dates. Okay, in order to illustrate, okay, I give the example, one example. Okay, you can see in the slide. On 1st January 2007, for example, A business, asset value of A's business is RM ringgit Malaysia to 100,000. And on the 31st of December 2007, the value of the asset is 225,000 ringgit. So the profit of A's business here is 200 okay, 225,000 ringgit Malaysia minus 200,000 ringgit, and the total is 25,000 ringgit. Yeah, 225,000 minus 200,000 ringgit, so the total is 225,000 ringgit. So this is the concept of gross profit. However, under the Partnership Act, partners are sharing net profit, and not gross profit. So only net profit will be considered as the profit, which fall under the profit, characteristic under the definition of Section 3(1). So for gross profit, it will not create a partnership. Okay. So the important element is profit motive. Yeah, for two parties, two person run a business, yeah, to get the profit. Yeah, the profit motive is important, and it is immaterial whether the business successful or not, to get the profit or loss. But the motive, to get profit is so important at the early stage of the business. Okay, in the case of Ratna Amal and another versus Tan Chow Su, in this case, the parties entered into an agreement to form a syndicate, for the purpose of selling condensed milk. The word partnership was not used in the agreement. Instead, the word syndicate was used. So in this case, from the facts, the court looked at the characteristic, whether they've successfully fulfilled all the characteristic under Section 3(1). So from the facts, it shows that the relation of the parties had the business character of a partnership. Okay, and therefore, notwithstanding the avoidance of any reference in the agreement to a partnership and the use throughout of the word syndicate, the arrangement arrived at was in fact a partnership. Yeah, so they had agreed to carry on this business in common with a view of profit. So, based on the judgment given by the court, based on the facts, yes, it is clearly showed that both parties had a business, they had run a business, and even though in the agreement, the word used in the agreement was a syndicate, not a partnership. However, all the characteristics of partnership were successfully satisfied. So the court held that they were partners. Yeah, the parties in the contract was they were partners. All right. So basically there are three characteristics, yeah, in order to determine, yeah, whether there is a partnership or not between the parties. Yeah, according to section 3.1, yeah, there must be a relation, yeah, between the two person, at least two, yeah, and to run a business in common. And the third one is with a view of profit. All right. So all of these characteristics under section 3 clause 1 should appear, in order to prove there is a partnership between parties. Why it is so important? Because to establish a partnership between parties, since okay, all of these three characteristics should be satisfied, in order to establish a partnership between parties. So it is important to establish a partnership between parties, since the formation of it entails certain obligation and liabilities, yeah, for the partners. So if they were partners in the partnership business, then all of them will bear the same liability, yeah, with the firms, yeah, with the firm, or with all the partners in the firm. All right, now let's move to the next issue. Okay, where some consideration, even though under section 3 clause 1, based on the definition of partnership, it laid down three characteristics in order to satisfy, to establish a partnership between the parties. However, if where a partnership agreement does not exist, section 4 of Partnership Act provides a number of tests, in determining the existence of a partnership. So these are the circumstances which are not prima facie partnership, even though you can see that from the contract, from the based on the facts, or situation, in based on the situation, it shows that all of the requirement under section 3.1, or all the characteristic under section 3.1 is successfully satisfied. However, according to section 4, it does not create partnership. All right. Okay, the first one, okay, section 4 of the Partnership Act 1961 provides that in determining whether a partnership does or does not exist, regard shall be had to the following rules. Okay, for the first one is under section 4 clause A. Okay, section 4 clause A stated that joint tenancy, tenancy in common, joint property, or part ownership does not of itself form a partnership. All right. So based on section 4, okay, what does it mean by section 4A? Section 4A, Okay, according to section 4A, okay, if anyone, any person, let's say, two person have joint tenancy. Yeah? They have joint tenancy, or they own one property. Yeah, one property with two names, two owners, two owner, or they have shares. Yeah, any profit. Yeah, from make use of the property jointly. Yeah, then it won't create partnership. So to illustrate further, yeah, let's look at the case of Davis versus Davis. Okay, in the case of you can for the case you can refer to your reference book at page 125. Yeah. So according to section 4 clause A, partnership does not exist between tenants, regardless whether they share or not the profit gain through the use of the land. So in the case of jointly owned property, it does not of itself form a partnership between the owners. So in the case of Davis versus Davis, all right, the facts, for the facts of the case, a father give his business and 3 houses to be shared together by his two sons were rented out, and the sons, two of the houses were rented out, and the sons used part of the money earned from the rental of the house to improve the business and share the other remaining portion equally. Okay, based on the facts of the case, it stated that yes, the father gave his business to his two sons, together with 3 houses, where these 3 houses shared together by his 2 sons. And then the son used part of the money earned from the rental to improve the business, also shared the other remaining portion. So here the court held that, in fact, there were 2 issues in this case. Okay, the first one is the business, Okay, the business, even though both of them shared a business, but that business was a partnership. Yeah, the business was a partnership between the sons. Yeah, but the joint ownership of the houses and equal share on the earnings did not make them partners. Yeah. Okay, why? Yeah, even though they have satisfied all the element, all the characteristic and the section 3 clause 1. However, section 4.2 provides otherwise. Yeah. So jointly, equally shared the earning from the houses and ownership, joint ownership of the houses does not make these 2 sons as a partner. Okay, the next one is section 4 clause B. Okay, according to this section, the sharing of gross returns does not itself establish a partnership. Yeah, whether the parties share the returns, have or do not have a joint common rights or interest in any property from which or from the use of which the returns are derived. All right. So it's stated clearly the sharing of gross return. So in order to constitute a partnership, it involves the sharing of net return, net profit, not gross profit. So whether they share the returns, have or do not have a joint common rights or interests, so it does not create a partnership. Yeah. Okay, to illustrate this principle, the second principle under section 4B, you can refer to the case of Cox versus Colson at page 126. Okay, where in this case, the defendant, a manager of a theatre, entered into an agreement with Mill, yeah, whereby Mill would prepare and pay for the theatre show, while the defendant would prepare and pay for the rent of the stage and lighting services for the shop. Okay, so based on the facts of the case, you can say that both of them have separate liability. They have a particular task to be done. And it was agreed that the defendant would receive 60% from the gross returns, and Mill would receive the remaining 40%. So it's clearly stated. They use the term gross returns. And during the show, okay, the plaintiff suffered injury, and he sued the defendant for liability as a partner of Mill, since Mill preparing for the theatre show. So the plaintiff, that's why the plaintiff intended to sue Mill and together with the defendant, because he assumed that the defendant was a partner of Mill. Okay, so the issue here was that whether the defendant is jointly liable. So the court held that even though the defendant and Mill shared the gross returns from the business, it did not make the defendant and Mill as a partner, because both of them had separate responsibility and liability. The defendant was liable to pay for the rent of the stage and lighting services from the 60% returns he received. And Mill, on the other hand, would settle the journey expenses, salaries of the actors, the cost incurred during the show from the 40% returns he received. So this showed that no partnership being formed between those parties. Thus, the defendant was not liable to the plaintiff. So only Mill had to pay for the liability for the damages, for the damage because to the plaintiff for injury suffered during the show. Okay, the next one is section 4 clause C. Okay, according to section 4 clause C, the receipt by a person of a share of the profits of business is prima facie evidence that he is partner in the business. But the receipt of such a share or of payment contingent on or varying with the profits of a business does not of itself make him a partner in the business and in particular. All right. So based on section 4 clause C, okay, it is pertaining to the sharing of profits. Basically, if we refer to the characteristic under section 3 clause 1, it's stated that the sharing of profits is one of the proof or evidence that someone is a partner in the business. However, the receipt of profit does not itself make someone as a partner. Okay, because this is not receiving a profit does not a prima facie evidence to prove that someone is a partner. So that usually the court will look at another facts in order to decide whether a person is a partner or not. Okay, so under section 4C, okay, there are several situations. Listed under section 4C as evidence to prove that in certain situation, even though someone has received profit from the firm, but it does not make him one of the partner. Okay, according to section 4 clause C clause 1, the receipt by a person of a debt or other liquidated amount by installments or otherwise out of the occurring profits of a business does not itself make him a partner in the business or liable, yeah, as such. So here payment of a debt, yeah, out of the profit of business to a creditor by installment does not make the creditor a partner in the business. Yeah, for example, A lends B a sum of money, let's say RM 10,000 ringgit, and A receives a sum of 1,000 ringgit per month, from the business as a repayment of the loan. So though the payment of RM 1,000 per month to A comes from the profit of the business, but A is not a partner to B, in a business. A is a creditor. Okay, so that is an example to illustrate the principle under section 4, clause C, clause 1. Okay, the case to illustrate is the case of Baddeley versus Consolidated Bank. Okay, in this case, you can turn to page 126 here, for the facts of the case. Okay, in this case, X intended to build a railway transportation and borrowed money from Y to finance the project. And as a security for the loan, X charged his machineries and agreed to pay an interest of 10% of the loan amount and 10% from the profit of the project to Y. So in this case, the court held that the advance given by Y to X creates a lender-borrower relationship. So Y is not a partner to X, though he received the payment from the profit of the business, but it does not create, it does not establish a partnership relation between those parties. Okay, the next one is section 4, clause C, clause 2. It provides that remuneration to a servant or an agent of the business from the profit of their employer's business does not create a partnership. So any form of payment, to a servant or an agent, which comes from the employer's business profit constitutes salary or wages. So therefore, a servant or an agent is not a partner in the employer's business and has no partnership liability. All right. So basically, this provision is quite self-evident, where the relationship of employer and employee is inconsistent, with the relationship and with the partnership, The relationship of employer and employee is inconsistent with partnership and that of an independent agent. Example, an estate agent engaged to sell the partnership office, for example, and is clearly distinguishable on the basis that there is no involvement in the business. So what this provision does is to make it quite clear that if such a relationship has been established by other factors suggesting either a contract of service or an independent contractor, the mere fact that he is to be paid out of the net profit of the business, so it will not make him a partner. So the effect of section 4, clause C, clause 2 of the Partnership Act was discussed in the case of Abdul Ghafur versus Muhammad Qasim and others. Okay, where in this case, the plaintiff was a dispatch clerk in the defendant's firm. So he was then appointed as a manager in one of the firm's branch office. One of the firm's documents stated that the profit from the firm would be divided into 79.4 parts and would be shared between the plaintiff, the defendant, and other partners. The plaintiff contended that he was a partner, but the defendant argued that the relationship was a mere employer-employee relationship. So the court held that the receipt of salary from the profit did not make the plaintiff a partner of the firm, because in this case, the relationship between those parties were employer-employee relationship. Even though there was the document stated that the profit from the firm would be shared between the plaintiff, defendant, and other partners. So we can say that it was general. It was general terms, and so but it is in order to decide this case, the court look at the relevant facts, and also the receipt of the position of the plaintiff himself, and the court held that the receipt of salary from the profit does not make the plaintiff a partner. So there was no partnership between those parties. Okay, the next one is section 4, clause C, clause 3. Payment of an annuity or a portion of the profits to a widow or child of a deceased partner in the business did not make them partners in the business. All right. So regarding section 4, clause C, clause 3. Okay. This is pertaining to the issue of widow or child of a deceased who receiving the portion or annuity, a portion of the profits from the business in which the deceased person was a partner. And it is not unusual for partners to make provision for their dependents in the event of their death. And one way is to provide in the partnership agreement that a partner's widow or children are to receive a specified proportion of the profits of the business after his death. So such a receipt is clearly no evidence of partnership. And they only receive the rights of for the deceased partner, and this will not make them a partner. Okay, to illustrate this principle, okay, in the case of Commissioners of Inland Revenue versus Libas Trustees, where in this case A, a partner in a firm bequeathed that his right to profit would be given to his wife upon his death. However, the partner did not perform the bequest, and therefore the Inland Revenue imposed certain tax for the amount which the widow was supposed to receive. And in this case, the court held that A's widow is not a partner of the firm, therefore her portion of money must not be taxable, because it does not constitute a profit, but it is the rights of the deceased partner. Okay, the next one is section 4, clause C, clause 4. Okay, payment of interest which varies with the profits on a loan advance for use in the business under a written contract. So a person who gives advance payment, yeah, by way of a loan, and he receive a payment of interest which varies according to the profit of the business, is not a partner in the business. Okay, so for the principle under section 4C4, so the central issue here, yeah, is the distinction, between a partner as a credit and a creditor. So the two paragraphs here under section 4C 1 and 4C4 provide a more specific guidance on this issue. Yeah, because if we look at we look again to section 4 clause C clause 1 states that a receipt by a person of a debt or other liquidated money amount by installments or otherwise out of the accruing profits of a business does not of itself make him a partner in the business or liable as such. And section 4C clause 4 continues the advance of money by way of loan to a person engaged or about to engage in any business on a contract with that person, that the lender shall receive a rate of interest varying with profits or shall receive a share of the profit arising from carrying on the business, does not of itself make the lender a partner with the person or persons carrying on the business or liable as such. So paragraph 1 therefore relates to the payment of the loan itself out of the profits, whereas section 4C4 applies to the repayment interest on a loan out of profit. All right. So the case, to illustrate further, okay, in the case of Riyang ex parte Jones, Riyang XP, sorry. Okay, Riyang ex parte Jones. Okay, where in this case, Y and J entered into an agreement whereby J advanced £500 to Y, and in consideration, J would receive £1 a week out of the profit gained from Y's business. J also helped in the management of the business and was given certain power to manage. So the court held that the receipt of the payment from the profit of Y's business does not make J a partner, although J was authorized to deal with the business. So both provision, the effect will be the same, where the partners will not, the person will not be a partner. Okay, the next one is section 4 clause C clause 5. Payment to a seller of the goodwill of a business in the form of a share of the profits of the business does not make him as a partner. So according to section 4 clause C clause 5, a person receiving by way of annuity or otherwise a portion of the profits of a business in consideration of the sale by him of the goodwill of the business is not, by reason only of such receipt, a partner in the business or liable as such. So the intention is clear, to protect the vendor of a business who agrees to sell the goodwill of that business by reference to the future profit of the business. So the court will be concerned to see whether or not this is the relationship between vendor and purchaser. So if it is, then there will be no partnership. And on the other hand, if the reality is that one partner is taking and another active partner who is buying his way into the business, nothing in section 4 clause C, clause 5 will save him. Okay, in the case of Rawlinson versus Clark, a doctor sold his business and introduced his clients to the buyer. In consideration, he received certain payment and shares from the profit made in the first year of the business. And the court held that he was not a partner to the buyer. So although the doctor received payment out of the profit of the business, but it does not make him a partner to the buyer. All right. So basically, for partnership, in order to constitute a partnership, all of the characteristic under section 3 clause 1 should be there, should be satisfied. However, there are some characteristic under section 4, all the characteristic under section 4 need to be considered, because it won't create a partnership relation between those partners. Okay, in order to form a partnership, for the formation of partnership, all elements of a valid contract must be present. For example, the element of partnership, the element of valid contract. For example, an offer, there must be an offer and acceptance, consideration, intention, competency, free consent, the lawful purpose. All of these elements should be present. And also the relation between partners concerning rights and duties will usually contain in the agreement or defined by the Partnership Act 1961. Okay, distinct from a company, a partnership firm has no separate legal entity from its founder under the law. And a partnership is the relationship between individuals who intend to do a business in common together. So partnership agreement can be made orally or in writing. Both will constitute a valid contract, and it must be registered. Registered in the registrar of register SSM, Register of Business, Registrar of Business, and along with the article of partnership or partnership agreement. But this document, article of partnership or partnership agreement, is not mandatory. It is not mandatory. So if the firm does not have its partnership agreement, so any disputes, the court will refer to the Partnership Act 1961. And partnership is not a legal person by itself, where the partners and the firm is considered as one entity. That's why it has unlimited liability, and the partnership should be established with lawful purpose. Under section 47(2), provides that a partnership is also considered as illegal if the number of partners exceeds 20%. This is for the normal partnership, ordinary partnership. All right. One of the elements of a valid contract is capacity. Regarding the capacity, the general rule of capacity is everyone sui juris is capable of entering into a partnership agreement. Okay, sui juris means that everyone with the full capacity, means that someone who has attained the age of majority is capable of entering into a partnership agreement. However, there can be a partnership between a minor and an adult where it also will create a valid partnership relation. However, regarding minor, for the partnership partners who are minor, they will not be liable for all the firm's debts and contractual liabilities. And on reaching the age of majority, he can withdrawing himself from the firm in order to discharge himself from all liabilities or debts of the firm. So if he remains in the firm until he attains the age of majority, then he will also be liable with the other partners. But if let's say before he is attained the age of majority and he withdrawing himself from the partnership, then he will not be liable. Okay, in the case of William Jacks and Co. Malaya Limited versus Chan and Yong Trading Company, Jack claimed a sum of RM 12,734 ringgit 91 cent, being the payment of the goods sold to the defendant who were partners in the firm. Young, who was a minor partner at the time of the purchase of the goods, did not defend his case, but Chan denied that the goods were for Young's personal use. Therefore, other partners were not liable for the claim. And in this case, the court held that even though the goods were bought for Young's personal use, it did not mean that the firm and other partners were not liable, since Young did not take any action to terminate his partnership upon attaining the age of majority, then he was also liable as a partner. Okay, the next one is pertaining to partnership agreement. Okay, for partnership agreement, it can be made orally in the form of oral or in written agreement. And the partners may have partnership agreement in writing, which is known as article of partnership. But in the absence of article of partnership agreement, the provision of the Partnership Act 1961 will be applicable to all the partners. All right, this is the provision pertaining to registration of partnership. The relevant provision which govern the registration of partnership. The first one is Registration of Business Act 1956. This is specifically special for Peninsular Malaysia. The second one is Sarawak Chapter 64, Trade Licensing Ordinance 64 and Chapter 33 for business name, business profession and trade licensing in Sarawak. The third one is Trade Licensing Ordinance number 16 in Sabah, and failure to register the partnership does not make a contract entered into by partners of the firm void ab initio. So even though the partnership does not register their partnership, it does not make the contract entered into by the partners. They're void from the beginning. It means that the contract is still valid. Okay, now let's move to to the relation between partners and third party. This is pertaining to the partner's authority as an agent, where basically for the partnership, the principle, agency principle will be applied. And as partners are agents of the partnership firm, so any act or omission committed by one partner binds the rest of the partners if it is carried out within the ordinary scope of the firm's business. And basically, partners' authority can be divided into two types. Yeah, the first one is actual authority, and the second one is apparent authority. And for actual authority, it can be further divided into two categories, which is express authority and implied authority, or apparent or ostensible authority. So express authority may be given in writing, yeah? May be given in writing as in the partnership agreement, or it may be given orally. And for implied authority, it is inferred from the conduct of the parties. Yeah, and it's varied, yeah, depends on the case, yeah, facts of the case. And for apparent or ostensible authority arises when the partner holds out to others that he has such authority, but in fact he does not have the authority. He does not having the authority. This is according to Section 8 of Partnership Act. Okay, so a partner has an authority to bind the firm if he carries out the partnership business within the scope of authority. So according to Section 7 of the Partnership Act, it provides the power of partner to bind firm. All right, Section 7, yeah. Okay, this is the okay, Section 7 of the Partnership Act 1961. Okay, every partner is an agent of the firm and his other partners for the purpose of the business of the partnership. And the acts of every partner who does any act of carrying on the usual way business of the kind carried on by the firm of which he is a member will bind the firm and his partners unless the partner so acting has in fact no authority to act for the firm in particular matter. And the person with whom he is dealing either knows that he has no authority or does not know or believe him to be a partner. All right. So according to Section 7, yeah. Okay, if we look at the first paragraph, yeah. Okay, the first paragraph, every partner is an agent of the firm and his other partner for the purpose of the business of partnership. Okay, according to the first limb, yeah, we can call this the first sentence as a first limb. A partner is thus an agent, yeah, and if he has the requisite authority, his principle here is referred to other partners, will be bound by his acts. So if it is therefore important that we understand exactly what can amount to authority for this purpose, and does such drastic and far-reaching effects on the liability of others. Okay, before 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 I explain further, okay, what is authority? Okay, authority basically is a mandate, mandate given to an agent by the principal to perform a particular act or services of an act for them. So it can be conferred expressly or may arise by implication, from appointment or acquiescence in the assumption of a particular office or status or as an incident of the performance of another more particular mandate. So this is the authority. And further, you can refer to another limb. Yeah. So the next limb where from the next limb, there are it stated for conditions, for partners to bind the firm. Okay, it's starting from this this point, until at the end of the provision. Okay, there are 4 conditions under section 7 to be satisfied in order to bind the firm by the act of the partners. Okay, the first one is it is the act of carrying on in the usual way business of the kind carried on by the firm. So for this, the first condition, the court will take into consideration, into account, the reasonable man view of the matter as to whether it relates to the firm's business or not. So if, sorry, okay, if it relates to the firm's business, then the court, it is considered as in the usual way of business, or of the same kind carried on by the firm. Okay. To further illustrate, we can refer to the case of Mercantile Credit Company versus Garrod, where in this case, P&G were partners in a firm which carried on a garage business. And their partnership agreement stated that their usual scope of business would exclude the buying and selling of cars. And P, without G's authority, sold a car to which he had no title to Mercantile Credit Company Limited for 700,000, 700 pound, and the company brought an action to claim back 700 pounds since P had no title to the car. Okay, based on the facts of the case, okay, both P&G, they were partners, and the business run by these 2 partners, they carried on a garage business, and it stated clearly that in their partnership agreement that their business would exclude buying and selling of car. So means that the partners was prohibited to buy or selling a cars. And then the plaintiff, he had sold a car where he had no title over the car, and then later the company brought an action to claim the money back. All right, the court held that the firm was liable, as the sale of the car to the company was an act of carrying on in the usual way of business of the kind carried on by the firm, within the scope of the Partnership Act 1961. Even though if we look at the facts clearly, the act of garage business, okay, the business of garage business and selling and buying a car is a different business, but using the reasonable man view, the court held that the sale of car was also an act for carrying on, means that it's fall within the ambit of garage business, so it come within the scope of the Partnership Act 1961. Okay, the second one, okay, this is the second condition under section 7. Okay, the act is necessary and usually done for the carrying on of business. Okay, in fact, section 7, yeah, uh, is dealing with the power, not the power, is dealing with the issue where the partner acting, yeah, without authority given by the firm. However, the firm is still liable. Yeah. Um, so in order to bind the firm, yeah, for any act done by the partners without authority, so these four conditions should be satisfied. Yeah. So if any one of these conditions fail to be satisfied, then the firm will not be bound by the act of the partners. All right. So this is the first one. So if that's why in the case of Mashanta Credit versus Company versus Garrod, even though P had done the transaction without authority, but still the court held that the firm was liable, yeah, because it's fall within the ambit of Section 7. All right. The second one is the act is necessary and usually done for the carrying on of the business. Even though the act was done without the authority given by the firm, however, if it is satisfied, the act is fall under the necessary and usually done for in the business, then the firm will also be held liable. Okay, what does it mean by usually acts of business? Okay, in the case of Bank of Australasia versus Brelat, excuse me. Okay, Privy Council has summarized the usual acts in a partnership as including pledging. This is all the usual acts done by the members in the partnership, partners in the partnership business. Pledging and selling of partnership goods, buying goods on the firm's account, borrowing money, contracting debts, and paying debts on its account, and drawing, marking, signing, endorsing, accepting, transferring, negotiating, and so on. So these are all the usual acts in for business. Yeah. Okay, in the case of Chan Kang Yu, okay, Chan King Yu versus Lee and Wong. The plaintiff the plaintiff husband borrowed from her 30, 35,000 ringgit as a loan, yeah, from her to the firm in which he was a partner. He gave her a receipt in the name of partnership. The money was paid into the partnership account and immediately thereafter utilized by the firm to pay off some of its debts. The plaintiff initiated an action to recover the loan, and the other partner of the firm contended that the plaintiff's husband was not authorized by the firm to borrow the money. So it is clearly stated here from the facts of the case that the plaintiff husband was acted without authority given by the firm to borrow the money. So the issue in this case was whether the firm uh, will be jointly liable, for the debt. Okay, it was held by the court that the borrowing was an act necessary for the carrying on of the business of the partnership under section 204 of the Contracts Malay States Ordinance, and as such bound the partner. So it means that the firm is bound. The firm was bound by the contract, by the debt. So the firm was liable to pay for the debt. So when I use the term firm, it refers to all the members, all the partners in the firm. Because firm, when we talk about a partnership, we need to use the word firm, not a company, because a company and partnership is these are two business different business entity. So for partnership, we need to refer as a firm. So when we refer partnership as a firm, it means that we refer to the all partners in the firm. Yeah? It means that we refer to the all partners in the firm. Okay, the next one is section 8. Yeah, section 8 is dealing with partners bound by acts on behalf of firm. So any act or instrument relating to the business of the firm and done or executed in the firm's name or in any manner showing an intention to bind the firm by any person thereto, authorized whether a partner or not, is binding on the firm and all the partners. All right, provided that this section shall not affect any general rule of law relating to the execution of deeds or negotiable instrument. Okay, so this is another situation where any act done by partners will bound, yeah, will bind the firm, yeah, if the act is done by partners, using related to business, executed using the firm's name, and also showing the intention to bind the firm, yeah. So whether the person is authorized, was authorized, any person, yeah, authorized, or whether he is a partner or not, still it will bind the firm, yeah, and all the partners. And provided that this section shall not affect any general rule of law relating to the execution of deeds or negotiable instrument. Okay, the next one, the third condition is the third party dealing with the partner does not aware that the partner has no authority or does not know or believe him to be a partner. So condition, the third condition, the main keyword, yeah, under this third condition is the knowledge, yeah, knowledge of the third party. So whether the third party has knowledge about the restriction, yeah, is material. Yeah. Okay, for the restriction, for example, A has been informed about B's limited authority and B was unauthorized to order goods exceeding 15,000 ringgit. So A made a contract with B for the supply of electrical goods worth 17,000 to the firm. So here the firm was not bound by the contract, because A has the knowledge about the limitation given by the limitation authority given by the firm to B. However, he still continue to enter into a contract with B. So in this example, the firm was not bound by the contract, yeah, because in order to for the act done by the partner, say without authority, to bind the firm, A, in order to bind the firm, A as a third party should have no knowledge, yeah, about the regarding the restriction, yeah, given by the firm as regards to the authority of its agent. Okay, the next one is section 10. Okay, section 10 provides that if it has been agreed between the partners that any restriction shall be placed on the power of any one or more of them to bind the firm. Okay, this is for section 10. Okay, section 10 is regarding this is actually the agreement, yeah, among the partners, where yes, they have made an agreement to limit, to restrict the power of any one or more of them, yeah, to bind the firm. However, it still need to be referred to the third party, whether the third party is aware uh, about the restriction or not, or whether the third party has knowledge about the restriction or not. So if the third party does not have knowledge pertaining to the restriction, then still the firm will be bound by the contract. Okay, the fourth one, the fourth condition is the outsiders knows or believes that the person who are dealing with him is a partner. Okay, this is also pertaining to the knowledge, or whether the outsiders, the third party, believes or knows that the person who are dealing with him is a partner. So if he believes that the person who are dealing with him is a partner, even though in fact he was not a partner, he is not a partner, then still the firm will be bound by the contract. Okay, in the case of Sitambaram Chetty versus Hong Hing and others, in this case, two persons established in 1922 a business in Penang for the sale of medicated wines. Their connection with the business was not made public and they took no part in carrying it on. They entrusted its entire control to two managers, the second defendant and 1C, and there was nothing in the circumstances to make it appear to those dealing with the firm that the managers were not partners or proprietors. And the second defendant borrows money from the plaintiff in the three actions upon promissory notes drawn in the name of the firm and absconded. Okay, based on this case, yes, two persons established a business in Penang to sell medicated wines. So it stated from the facts of the case that their connection with the business was not made public, means that the third party have no knowledge that the position of each of these person, whether there are employee or partners in that business. So in this case, when they entrusted central control to managers and the second defendant and C, so nothing in the circumstances to make it appear to the third party who those dealing with the firm that the managers were not partners or proprietors. So the outsiders will assume that the people who are dealing with them are the partners in the firm. Okay, so in this case, Peringkat J held that whatever was the real position of the second defendant, the knowledge partners did allow him to carry on particular business as an ostensible principle, and therefore the firm was liable because excuse me, if you look at the facts of the case, it gives the presumption to the third party that the managers are the partners for the firm. So because of that reason, the firm was liable. Okay, now let's move to the next point, which is liability of partners. And as far as liability of partners is concerned, under the Partnership Act 1961, there are several types of liabilities, namely contractual liability, tortious liability, liability for improper use of trust property, and for holding out criminal liability and liability of incoming and retiring partners. Okay, now let's look one by one. of this liability in order to determine whether the firm or the partners will be jointly liable or personally liable for the act done by another partners in the firm. Okay, the first one is contractual liability. According to section 11, section 11 of the Partnership Act 1961, sorry. Okay, section 11 provides that every partner in a firm is liable jointly with the other partners for all debts and obligations of the firm incurred while he is a partner. And after his death, his estate is also severely liable in a due course of administration for such debts and obligations, so far as they remain unsatisfied but subject to the prior payment of his separate debts. So basically, according to section 11, it provides that joint liability of partners in matters concerning contracts entered into by the firm with third party. So all partners will be jointly liable. So the joint liability under this section means that every partner is liable for all the debts and obligations of the firm. For example, if A, B and C, who are partners in a printing business, bought a printing machine worth Rm 15,000 ringgit by credit, so A, B and C shall be jointly liable for the payment of the sum. And besides the liability of partners, section 11 also provides for the liability of deceased partner, where the deceased partner also will be jointly liable for the with the firms for the firm's debt if the debts incurred during his term as a partner of the firm. Okay, in the case of Osman bin Haji Muhammad Yusof versus Chang Kan Sui. Okay, in this case, a partner has been formed by 6 partners. A partnership has been formed by 6 partners, including the appellant. 3 of the partners borrowed Rm 10,000 from a third party by effecting a promissory note. The loan was guaranteed by the respondent. The respondent here was Chan Kang Sui. Later, the firm failed to pay the debt and Chan was called to pay for the debt on his own account. He then initiated action against the 6 partners for recovery of his money, and 5 partners accepted their liability except the appellant. So in this case, the court held that the debt was a firm's debt and was obtained for the purpose of partnership. The partners who signed the promissory note had acted for the firm and they were authorized to do so. Therefore, the firm or the 6 partners were liable. So from this case, all of them are jointly liable for the debt, for the firm's debt. Okay. And further, section 11 also provides the liability of a deceased partner. Okay, for the case, you can refer to page 134 in your reference book. Okay, under section 11 also provides the liability of a deceased partner, where under this provision, the deceased partner is jointly liable for the debts, firm's debt incurred during his term as a partner of the firm. This means that if a creditor sues the firm for the firm's debt but fails to recover full satisfaction of his claim, he can recover from the administrator of the estates of the deceased partner. However, payment to the creditor is subject to the settlement of the deceased partner's personal debt, if any. So, in order to apply section 11, to render all the partner to be jointly and severally liable for the suit claim against the firm, So to invoke this provision, it is sufficient, it is suffice to prove that the partner is a partner of the firm at the material time, when the alleged liability occurred. And it is irrelevant for the partner to deny another partner's act, since the suit against partnership is equal to suit against all partners of the firm. Okay, the second one is tortious liability. Okay, Section 12 of the Partnership Act 1961 provides for liability of firms for wrongs or tortious liability of partners. Okay, when we talk about tortious liability, it refers to civil wrong. And the example of tortious act are nuisance, defamation, trespass, negligence, and so on. And in partnership, tortious liability, tort may occur in the situation. For example, A, B, and C are partners carrying on business of repairing electrical equipment, for example. So C repaired a microwave oven for a customer, but due to his negligence, the customer was electrocuted when using the microwave oven. So in this case, C was negligent in performing his work, and therefore the firm and other partners were liable to the customer. So according to Section 12, it provides that whereby any wrongful act or omission of any partner acting in the ordinary course of the business of the firm or with the authority of his co-partners, loss or injury is caused to any person not being a partner in the firm, or any penalty is incurred, the firm is liable, therefore, to the same extent as the partners who acting or omitting to act. So, for the tortious liability, all the partners will be jointly liable. Okay, in the case of Hamlin versus Houston and Co., H and S were partners in a firm. Okay, you can refer to page 135. H bribed a clerk of another firm to get secret information on contracts and tenders of the said firm. The court held that H, as the partner, had done illegitimately that which was part of his business to do legitimately. Hence, the firm was liable for his act. So, in this case, the firm was liable because the bribe was part of the firm's money, and such information was for the purpose of the partnership business and would have been legitimate if obtained by proper means. Okay, however, it is important to note that there is nothing in Section 12 of the Partnership Act which infers that liability of the firm incurred by reason of a wrongdoing of a partner cease once the errant partner ceased to be a partner of the firm. So, the liability will be continued, as long as the partners okay, but still, even though the partner has ceased or ceased to be the partner in that firm, but still he still continue. He still has to bear the liability, with all the partners in the firm. Okay, the third one is liability for improper use of trust money. Okay, liability for improper employment of trust money, trust property for partnership purposes is provided under Section 15 of the Partnership Act 1961, where it provides that if a partner, being a trustee, improperly employs trust property in the business or on the account of the partnership, no other partner is liable for the trust property to the persons beneficially interested therein, provided This section shall not affect any liability incurred by any partner by reason of his having notice of a breach of trust. And the second one is nothing in this section shall prevent trust money from being followed and recovered from the firm if still in its possession or under its control. So for improper use of money of trust property, the liability is only on the partner uh, who has done the improper use of trust money, the improper use of trust money. So all the partners, they will not be jointly liable, only personally liable. Okay, in the case of ex parte Heaton, a father and sons were partners in the firm. The sons used the trust property for the purpose of the firm's business. When the firm became bankrupt, the court held that the money which had been misappropriated could not be recovered from the partnership property because the father had no knowledge of the breach of trust committed by his son. Okay, so according to this case, his son will be personally liable for the breach of trust, but the other partners will not be held liable. Okay, the next one is liability for holding out under section 16. Usually in the firms, in partnership, a person who is not a partner of a firm may become liable for the firm's debt if he represents himself or allow himself to be represented as a partner in the firm. Because usually in the partnership business, those who are the partners, they will be jointly liable for any debts incurred during the partnership. However, let's say if a person, he is not a partner, but he represents himself or allow himself to be represented as a partner in the firm. So in that situation, he will be liable like a partner to the person who gives credit to the firm. Okay, where section 16 of Partnership Act provides that everyone who by words spoken or written or by conduct represents himself or who knowingly suffers himself to be represented as a partner in a particular firm is liable as a partner to anyone who has on the faith of any such representation given credit to the firm, whether the representation has or has not been made or communicated to the person so giving credit by or with the knowledge of that apparent partner, making the representation or suffering it to be made. So basically, for liability for holding out, this is a liability for holding out. So basically, this liability is based on the principle of estoppel because in fact, the person who is represent himself or allow himself to be represented, basically he is not a partner in the firm, but he represented himself as a partner. So if any contract uh, established between the firm and the third party because of that representation, then he will therefore be liable like another partner to the person who gives the credit to the firm. And okay, and after a partner's death, the partnership business is continued in the old firm. For example, let's say one of the partner was died, and the partnership business is continued using the old firm name. So the continued use of that name of the deceased partner's name as part of the business shall not itself make his executors or administrators estate or effect liable for any apparent partnership debts contracted after his death. So for the partner's death, after the partner's death, if the business is still continued using the firm's old name, the old firm's name, then and the deceased partner's name still was still listed in the partners uh, partnership in the partnership cover letter, for example, then any debt incurred contracted after his death he will not be liable. So when a person makes a representation that induces third party to believe and rely on such representation that he is a partner, even though he is not, so the person is estopped. Estopped means he is prohibited from denying or contradicting the statement. That's why he will be held liable, jointly liable with all the partnership or all the partners in the firm. Okay, in the case of Re Buchanan, okay, the court held that the court stated that if the holding out or representation is made without the knowledge or consent from the real partner, only the person holding out as a partner shall be liable to the third party acting in reliance of the representation. Right. Okay, the next one is liability for criminal offences. Okay, basically, any partner who commits criminal offences shall be personally liable. They shall be personally liable. So, other partners shall not be liable unless there are evidence to prove their participation in the commission of the crime. Okay, as regards to criminal offences, the partner will be personally liable for the crime, for the criminal offences made during the partnership. So the other partner will not be liable unless there was evidence that they also involved in that offences. All right. Check this. Okay, in order to illustrate further, we can refer to the case of Chung Shin Kian versus Pendakwa Raya, where in this case two partners in a firm had used a trade name Texwood. Texwood belonged to another company on their products. There was no evidence to prove that the second appellant was involved in the crime except as to become a partner in the business. So thus the appeal of the second appellant was allowed, because according to the facts of the case, even though there were two partners in the firm, but only one was held liable for the offence because the second partners, the second appellant, there was no evidence to prove that the second appellant was involved in the crime. So as regards to the liability for criminal offences, the partners will be personally liable for the offence, for the crimes offence. Okay, the next one is liability of incoming and outgoing partners. Okay, outgoing partners is referred to retiring partner. So according to section 19 clause 1, a person who is admitted as a partner into an existing firm does not thereby become liable to the creditors of the firm from anything done before he became a partner. So what does it mean here? From section 19 clause 1, a person who is admitted as a partner, he is an incoming partner, a new partner, he does not become liable to the creditors of the firm for the debt which incurred before he became a partner. except by novation. Novation here is a new agreement agreed between two parties, or three parties, yeah, namely incoming partners and outgoing partners or retiring partners and the creditors, where uh, through novation, the incoming partner is agreed, yeah, to help liability, yeah, on behalf of the retiring partners, yeah. So and the creditors also will be mutually agreed with that agreement. So if there is a novation agreement, means that the incoming partner will be held liable for any debts, yeah, done or incurred before he became a partner. But this must be made in mutually, yeah? The agreement need to be mutually agreed, yeah, by all the parties to the contract. Okay, the next one is Section 19, Clause 2 of the Partnership Act 1961. A partner who retires from a firm does not thereby cease to be liable for partnership debts or obligation incurred before retirement. It means that a partner who retires from a firm, he still continue, yeah, to bear the liability for partnership debts or obligation incurred before his retirement. Okay, in the case of sorry. So for a person retiring from the firm, he is not free from liabilities before his retirement. So he remains liable for the partnership debts incurred before his retirement, as provided under Section 19(2) of the Act. And a retiring partner may only be discharged from liabilities by novation, yeah, same as the first situation just now that I have explained, by novation agreement between himself, the new firm, yeah, and the creditors. Okay, in the case of Duke versus Brewer, it was held that for a new incoming partner, if the liability was for a continuous contract, which was made before he became a partner and continued to exist before he became a partner, then he shall be liable for the same. This is pertaining to the liability of incoming partners. All right. Okay, now let's move to the next point. The relationship between partners. Okay, the relations between partners to one another are determined by their partnership agreement. And the partnership agreement normally provides for the rights and duties of the partners, the conduct and management of the firm, the capital, and their profit sharing arrangement. Yeah. So the Partnership Act 1961 applies in the absence of provisions being made under the agreement. So in Malaysia, it is common for there to be no written partnership agreement, and provision in the Partnership Act 1961 would therefore apply unless the partners have orally agreed on those provisions. So the interests and duties of partners in the absence of agreement to the contrary are provided for in Section 26 of the Partnership Act 1961. Yeah, this is under part 4. Yeah, under part 4, Section 21, Section 23. Okay, these are all the relevant sections pertaining to the mutual rights and duties of partners, okay, under Section 26 until Section 26A to Section 26I. And please bear in mind that okay, not all the partnership, yeah, not all the firm has its own partnership agreement or article of partnership. Yeah? If the partners did not provide the terms of partnership, yeah, they does not have partnership agreement, then partnership Act will be applied. Yeah? But if they have partnership agreement, but the issue arise, there is no terms of the partnership provided in the partnership agreement. Means that, for example, let's say the dispute is pertaining to the uh, pertaining to, for example, um, okay, pertaining to the profit sharing. Yeah. Okay. So if in the partnership agreement there is no specific terms expressly stated the profit sharing, how it should be divided or distributed, then the Partnership Act 1961 will be applied. Okay, the first one under section 26A. Okay, actually for mutual rights and duties of partners, I think you can read on your own because it is straightforward. But I will give to you. I will I just read it for you. Yeah, briefly. Yeah, and you can read on your own. All right, the first one is section 26A. Every partner is entitled to equal share of capital and profits of the business and must contribute equally to losses. Okay, this is if pertaining to section 26A, if there is no specific agreement between partners pertaining to the share, how to share the capital, how to share, how many profits should be shared in the business, or how to contribute, how much every partner should contribute to the loss of the firm, if the firm suffered loss. So if they have the specific terms in the partnership agreement, then the court will refer to the term. But if there is no specific terms pertaining to that issue, then the court will use section 26A. So any for as regards to the share of capital, or share of profits, especially, let's say if there were two partners in the firm and one of them uh, has contribute 60%, and another partner is contribute 40%. So if there has no partnership agreement, then for the share of capital profits, they need to, they're entitled, both of them entitled to equal share. Yeah, even though one of them has contribute more than that, 60%. And same as the losers. Okay, the second one is section 26B. Every partner who made any payment and incurred personal liabilities in the course of the firm's business is entitled to be indemnified by the firm. Okay, to illustrate, please read the case of Kok Hok Leong and another versus Siu Kah Cheng and another, where in this case, the appellant was entitled to be indemnified from the firm's asset because he has paid his own money. He was using his own money, to make any payment for the firm, and then he was entitled to be paid, to be indemnified from the firm's asset. The third one is every partner who made section 26C. Every partner who made any advance for the purpose of the firm's business beyond the capital amount of fee subscribed is entitled to 8% interest per annum from the date of the payment of the advance. Okay, this is another situation where every partner who made advance, he advanced his money for the purpose of firm business. Then he, beyond the capital amount he subscribed, he is entitled 8% interest per annum, yearly, from the date of the payment of the advance. Okay, section 26D, your partner is entitled to interest on capital before the ascertainment of profits. According to the case of Richten Grishel, the court held that a principal in a business was not entitled to the interest on capital until the employees and the agent remuneration has been ascertained. Okay, the next one is section 26E. Every partner may participate in the management of the firm. Yeah, since for the partnership, yeah, all the partners they were entitled to participate. However, this right, yeah, the rights of participation in the management can be limited, yeah, through the agreement mutually agreed by both parties. Yeah. In the case of Kelly versus Tucker, KMT had entered into a partnership agreement verbally, whereby they agreed to involve in the business of buying horses from Australia and to be sold in South Africa. By the said agreement, T would provide the capital while K was entrusted to manage the business. In this case, T's participation in the management of the partnership was denied by the agreement of both parties. Okay, the F, no partner is entitled to remuneration for acting in the partnership business. Okay, reason being is the existence of the fiduciary relationship. Yeah? Why no partners is entitled to be paid for acting in the partnership business? Because basically the relation between the partners in the firm uh, is the fiduciary relationship. Yeah? So any partner who is assigned to manage the business is duty bound to exercise such duty for the interest of other partnership of the partnership. So the partners are not entitled to any salary or wages because they are performing their duties as partner in the course of the partnership business. Okay, the next one is no partner may introduce another or new partner without the consent of other existing partners. It must be made, existing partners should be made, okay, for existing partner, sorry, okay, any partner who is assigned to manage the business is bound, is the duty, has the duty to duty to bound to exercise such duty for the interest of the partnership. So that's why the partner, yeah, is not entitled to for any salary or remuneration or wages, yeah, because they are performing their duties as a partners in the course of partnership business. Alright, the next one is section 26G. No partner may introduce another partner, new partner without consent of other existing partners. Okay, for this point, if one partner intended to introduce a new partner, incoming partner to the partnership business, it must be done. It must be done. It must be made. So the consent should be made by all the partners. Yeah, consented. Yeah. Uh, for the incoming partners, yeah, to join the firm. Okay, the last one, not the last one. Okay, the next one is section 26H. The majority partners may decide any differences to ordinary matters connected with the firm's business, but the changes in the nature of the firm's business must be made with the consent of all the existing partners. So here, any difference, any disputes, the majority partner may decide if there is any disputes in the firm which connected with the firm business, but any changes, it's only need for majority majority consent. But the changes in the nature of the firm's business must be made with the consent, with the consent of all the existing partners, as mentioned in the case of Hailey versus Walker. And the next one is section 26I. This is pertaining to partnership book. Yeah? So the partnership books are to be kept at the place of partnership business or at the principal place if there is more than one place of business. So it is important to note that section 26 of the Partnership Act 1961 It's only applicable in the absence of the partnership agreement between the parties. So in the existence of partnership agreement, the above provision are not applicable. So these are all the mutual rights and duties of partners, among the duties among them, and it will only applicable if there is no partnership agreement made between the partners in the firm. Okay, so I want you to read, to get better understanding. Please read and this provision and the case as well, cases as well. Okay, the next one is obligation of partners to act in utmost good faith. Okay, this is another rights and duties of partners in the partnership firm. Okay, this rights and obligation is provided under Section 30, Section 31, and Section 32, where under Section 30, every partner is obliged to render true accounts and full information on all things affect the partnership. So it is based on the principle of Uberime Fide. Uberime Fide means utmost the good faith. So under this section, every partner is obliged to render true accounts and full information regarding the accounts of the partnership. In the case of law versus law, a partner transferred part of his shares to another partner for £21,000, and the partner who bought the shares knew that the partnership asset comprised of securities and charges but concealed the facts from the partner's knowledge. So in this case, the court held that the partner who had the information must disclose the information, otherwise the sale of the shares may be set aside. Okay, the next one is under Section 31. Every partner who uses the partnership property, name or business connection or involved in any transaction concerning the partnership without the consent of other partners must account to the firm for any secret profit or benefit derived by him. Where this principle is illustrated in the case of Patirana versus Arya Patirana, 1967. Sorry, 1967, not 1976. It is 1967. Sorry. In the case of Patirana versus Patirana, a dispute arose between two partners who were the marketing agents for Caltex Ceylon Company, and the defendant gave 3 months notice to terminate the partnership. However, before the period of notice ended, the defendant entered into a new agency contract with Caltex under his own name. So the court held that the profit gained by the defendant from the agency contract belonged to the firm because the defendant had used this case when the defendant the court held that the profit gained by the defendant from the agency contracted belonged to the firm because the defendant had used the firm's goodwill, the firm's name, and to obtain contract before the partnership was dissolved. So the firm has the right to claim for the profit gained by the partners. Okay, the next section is section 32. Okay, section 32 provides that the obligation of a partner not to compete with the firm in business of the same nature without consent of the other partners. So if a partner opens a competing business without the consent of other partners, he must account for and render all profits made by him to the firm. Okay, so the according to section 32, the important things here in order for the partner to render the account, the profit to the all the profit made by him to the firm is if the business run by him, yeah, has the same nature with the firm business, and it is done without the consent of other partners, yeah, and also the business is competing, yeah, is competing, yeah, business with the firm, then also he must render all the profits made by him to the firm. Okay, in the case of S versus Benham, a partner is a ship brokerage firm assisted in the incorporation of a shipbuilding company using information he obtained from the firm's business. So he was then appointed as a director in the said company and received a salary in consideration for the services he rendered. Other partners claim for the benefit to be given to the firm. So in this case, the court held that other partners had no right to claim for the benefit since the shipbuilding business was of different nature from the brokerage business. Yeah, even though the main thing, yeah, in this business is shipbuilding, the ship. Yeah, however, the nature of the business was different. Yeah, the shipbuilding business and the ship brokerage is only to sell the ship, and the shipbuilding is only for to build the ship. Yeah? So because of the different nature of the business, then the other partner has no right to claim, yeah, for the benefit. All right. Okay, another rights of partners can be found under section 33(1). Yeah? This is pertaining to assignment of shares. Okay, so under section 33(1), yeah, of a partnership, a partner may assign his share if there is no agreement among the partners prohibiting the assignment. If the assignee, if the partner was assigned his share to another person outside the partnership, the assignee is not entitled to interfere. So the person, yeah, who received the assignment of share, who is assigned, yeah, for the share, we call it as assignee. So the assignee is not entitled to interfere in the management of the partnership business or to require any account to the partnership transaction or to inspect the partnership book. You can refer to page 145. So the assignee is only entitled to receive the share of profits to which the assigning partner would be entitled. Okay, to illustrate this rights here under section 33(1), please read the case of Ong Kian Lu versus Hot Wash Trading Company and others. Okay, the next one is partnership property. Okay, regarding to partnership property, it is important to determine whether the property used in the course of the firm's business is the property of partnership or it owns, it belongs to the individual's partner's property. Okay? It belongs to the partners in that firm. So section 22 and section 23 of the Partnership Act provides the guidelines on this issue. So according to section 22(1), states that all property and rights and interest in property originally brought into the partnership stock or acquired whether by purchase or otherwise on account of the firm or for the purpose and in the course of the partnership business are called in this act partnership property and must be held and applied by the partners exclusively for the purpose of the partnership and in accordance with the partnership agreement. And furthermore, section 23 provides that unless the contrary intention appears, property bought using firm's money is deemed to have been bought on account of the firm. So from the statutory provision and the decided case law, the following the conclusion can be made. The first one, in order to determine whether the property is belongs to the firm or belongs to the personal owner, personal partners in the firm, whether the question here is whether the property brought into the firm is a partnership property or property of an individual. It depends on the partnership agreement between those parties. So if the partnership agreement stated mentioned specifically pertaining to that issue, then uh, it will be determined accordingly according to the partnership agreement. Okay, in the case of Miles versus Clark, okay, a photographer who carried out his own business brought in a new partner who had many business contacts. There was no clear agreement between the partners, and later a dispute arose between them and the partnership was dissolved. So the court decided that since there was no clear agreement pertaining to the use of the asset in the partnership, so the asset were not partnership properties but owned individually by the partners who brought them into the firm. So the important thing here is that it must be stated clearly in the agreement whether the asset is belongs to the partnership of belongs to the firm or belongs to the individual partners. Okay, the second one, if there is no agreement provided for the partnership property, the partners must have the intention to regard the property as a partnership property. So the property is intended to be a partnership property when it is purchased using the partnership money. Yeah? Even though it was purchased under a partner's name, so the property will remain as a partnership property even though it is not used for the partnership business. So please read the case of Murta Castello to this case illustrate where the firm bought the property using the partnership asset, then it will be regarded as a partnership property. And another case is the case of Ponukon versus Jebaratnam. Okay, so the last one, this is the dissolution of partnership. Okay, so I want you to read all pertaining to the another rights of partnership at page 145, 146, 145, 146 until 148. Okay, so now let's look at the dissolution of partnership. This would be the last topic in the law of partnership. All right, a firm ceases to exist when it is dissolved. This means all the firm's business cease to operate upon dissolution of a partnership. So accept the obligations of the partners to continue to do the necessary for purpose of dissolution and completing the incomplete activities. So there are several ways in which a partnership may be terminated. So it can be terminated by expiration of term or notice under section 34. So this is pertaining to the partnership. If the partnership was established for the particular period of time, then when the expiry of the expiration of the term, then it will be automatically dissolved, or it can be terminated through notice. When the other partner, any partner giving notice to the other of his express his intention to dissolve the partnership. Okay, the second one is dissolution by death or bankruptcy or charge under section 35 of the Partnership Act. So subject to any agreement between the partners, every partnership is dissolved by the death or bankruptcy of any partner. So a partnership may also be dissolved if any partner suffers his shares of the partnership property to be charged under this act for his separate debts. And the next one is it can be dissolved, the partnership can be dissolved by supervening illegality under section 36, wherein if if any event happen where it makes unlawful for the business to carry to the makes it unlawful for the business of the firm to be carried on or for the member of the firm to carry it on in partnership, then it will be dissolved. Okay, pertaining to section 36, Okay, so for section 36, yeah, partnership, even though legally constituted at the beginning, yeah, it may become illegal at a later date, either because of a change in the factual circumstances or by virtue of legislation to that effect. So an example of a situation is the declaration of war, where it will affect many partnership. Yeah? Okay, the example of dissolution, by supervening illegality or by operation of law, yeah, uh, where you can refer to the case of Hajjal Yates and Co. versus Watson, where in this case a client of a firm of solicitor denied liability to pay the plaintiff's firm's bill of costs on the basis that as one of the partners, S, who inadvertently failed to renew his annual practicing certificate until May of the relevant year, had disqualified himself from acting as a solicitor. So the firm was precluded from recovering costs for work done for the defendant in that period. So in this case, by majority, the English Court of Appeal held that when S certificate lapsed, the existing partnership between himself and the remaining partners was automatically dissolved, since it was illegal for an unqualified person to be a member of a solicitor's partnership, but the partnership was reconstituted during the relevant period as a partnership between the remaining partners. Yeah. Okay. Because for the solicitor, it is the duty of the solicitor to renew his license, his practicing certificate yearly, yeah, yearly, in order uh, mm, to practice, yeah, to continue to resume practice as a solicitor. Okay, the next one is dissolution by court's order. Okay, under section 37. Okay, section 37A. Okay, provides for the dissolution, yeah, by the court when a partner is found lunatic, yeah, or is shown to the satisfaction of the court to be of permanently unsound mind, in either of which cases the application may be made as well on behalf of that partner by his committee or next friend or person having title to intervene, as by any other partner. So the Partnership Act 1961 makes insanity a discretionary ground for dissolution of a partnership. So Section 37A provides not only that application for dissolution may be made by the lunatic partners, but also that it may be made on his behalf by representatives. Yeah. Okay. The second one is under Section 37B, permanent incapacity, where Section 37B provides that when a partner other than the partner suing becomes in any way permanently incapable of performing his part of the partnership contract, so the other partner has the right um, to apply from the court to for the dissolution of partnership. Okay, the case to illustrate is the case of Whitwell versus Arthur. Whitwell versus Arthur, where in this case a partner in a firm of pharmacists was disabled by a paralytic stroke, and his co-partners applied to the court for dissolution of the partnership on the ground that the stricken partner was incapable of carrying out his duties in the partnership business. So the application was stayed on the ground that there was some evidence before the court that there had been a recent improvement in the disabled partner's condition. However, liberty to apply was reserved to the applicant in the event of there being a deterioration in his partner's death. All right, this is for the permanent incapacity of the partners. Okay, the next one is section 37C for prejudicial conduct. When a partner other than the partner suing has been guilty of such conduct as, in the opinion of the court, regard being had to the nature of the business, is calculated to affect prejudicially the carrying on of the business. So under this section, it is not necessary for the applicant to prove that the conduct of his partner, upon which the application is based, occurred in the course of or was in a way connected with the partnership business. Yeah, as stated in the case of England, yeah, in the case from England, Carmichael, Carmichael versus Evans, where the conduct of the expelled partner was quite unconnected with the firm drapery business, but the publicity attendant upon his criminal conviction was nevertheless held to be calculated to injure the firm's reputation in the eyes of its customers. Okay, the next one is section 37D. Yeah. When a partner willfully or persistently commits a breach of the partnership agreement, or otherwise so conduct himself in matters relating to the partnership business that it is not reasonably practicable for the other partner or partners to carry on the business in partnership with him. So this section may cover two different circumstances. First is where the breach of the agreement is intentional, intentional, whereas the second covers cases although the conduct of a partner may be unintended. It makes the carrying on of the business is in partnership impracticable. The problem in the first circumstances is whether the above section applies only to breach of the express terms of the agreement or whether it also extends to breach of any of the statutory duties that impose upon the partners of the Partnership Act. So in this case, Fletcher is one of, in the case of Australian case, argued that the statutory duties are entirely incorporated in the partnership agreement. So that breach at any one of them is a breach of the agreement. And in the other hand, even if such breaches do not come within the ambit of section 37D, they may constitute a ground for dissolution because it will be just and equitable, for the court to dissolve the partnership. Okay, the next one is section 37E, provides that when the business of partnership can only be carried on at a loss. So a partnership dissolution on this ground follows as a natural consequence from the definition of partnership under section 3 clause 1. So if partnership entails a view of profit, then it is only natural that the partnership should be dissolved when that end can no longer be attained. Okay, the next one is section 37F. This for just and equitable relief. Under section 37F, whenever in any case circumstances have arisen which in the opinion of the court render it just and equitable that the partnership be dissolved. So this section is final. It is the final ground which the court may order dissolution appears to give the court a very wide discretion. So the law relating to winding up of company on the just and equitable ground was carefully considered and authoritatively expounded in the case of Ibrahimi versus Westbourne Galleries Limited. Okay, where in this case, okay, I will not explain further for this case. Now let's look at the another case to explain or to illustrate for just and equitable reason for the court to dissolve a partnership. In the case of Yenich Tobacco Company Limited, where in this case the company was ordered to be wound up under the provision of the Companies Consolidation Act 1908, because the two persons who were the only directors and the only shareholders had reached such a state of personal antagonism that they refused to communicate with each other except through the medium of a third party. So the order was made in spite of the fact that the company's business was highly profitable, and in making it, so Lord Curzon's Lord Curzon's Hardy was the judge in this case, clearly indicated that the same principle were applicable to partnership. It can be dissolved, yeah, by the reason of just and equitable, yeah, and according to the opinion of the court, yeah. So these are all the reason, yeah, for dissolution of partnership. So basically, the partnership can be dissolved um, by the expiration of term of notice, or upon the death or bankruptcy of charge, yeah, or charge any of the partners in the partnership, or by supervening illegality. This is this dissolution by law, or it can be done by court order. It can be dissolved by court order, but upon the application made by the any one of the partners in the firm. All right, so I want you to refer to page 149 to 151. Yeah, for further clarification, yeah, regarding this topic. All right. Okay, and I think that's all for this session. So this is all. I have covered all the important topics, yeah, pertaining to the partnership law, law of partnership. So I hope besides this video, please read, yeah, also the reference book and additional reading, make additional reading. Okay, thank you for your attention. Bye.